dāmas un kungi, pulkstenis jau ir drusku pāri 10, un līdz ar to mums ir laiks sākt. Mans vārds ir Edijs Poga, esmu zierināts advokāts un biedrības Latvijas Tiesību institūts direktors. Biedrība Latvijas Tiesību institūts ir neatkarīga, nepolitiska, nevalstiska bezpeļņas apvienība, kurā apvienojušās personas ar kopīgām interesēm par Latvijas tiesībām un to attīstību. Institūts vienmēr un visur darbojas neatkarīgi un stāv ārpus politisko partiju vēstās politikas. Institūta misija ir veicināt Latvijas Republikas kā demokrātiskas taisnības un tiesību valsts tālāk atjaunošanu, nostiprināšanu un attīstību. Jau 3. gadu pēc kārtas mūsu ārvalstu akadēmiķu vieslekciju programmas ietvaros mēs rīkojam pazīstam Eiropas tiesību akadēmiķu vieslekciju Rīgā. Šogad pie mums esam aicinājuši uzstāties ar lekciju Londonas Karaliskās koledžas profesoru, bijušo Eiropas Savienības tiesas ģenerāladvokātu Karolīnas padomnieku Seru Francisu Džeikobsu. Es domāju, ka jūs piekritīsiet, ka profesoram Džeikobam nekādas garas iepazīstināšanas runas nav nepieciešamas, jo nav un nevar būt pilnīgi neviens Eiropas Savienības tiesību speciālists, kas nezinātu viņa vārdu un viņa lomu Eiropas tiesību attīstībā pēdējos 25 gadus vismaz. Ja? Tādēļ es bez gariem iepazīstināšanas ievadiem diezgan ātri došu vārdu profesoram pašam. Profesora Džeikobs šodienas vieslekcijas tēma ir Eiropas Savienības tiesas darbība, sevišķi apskatot prejudiciālo jautājumu sistēmu, kas jau vairāk kā 10 gadus ir neatņemams Latvijas tiesu sistēmas diezgan svarīgs elements. Šī sistēma ir svarīga ikvienai Latvijas tiesai un līdz ar to ikvienam Latvijas juristam, jo mūsdienās nomācošo vairākumu tiesību disciplīnu vienā vai otrā veidā skar Eiropas Savienības tiesības, un tātad to sakarā jebkura līmeņa Latvijas tiesām var nākties griezties pēc Eiropas Savienības tiesas palīdzības, uzdodot prejudiciālu jautājumu par Savienības tiesību iztulkojumu vai spēkā esamību. Šīs vieslekcijas mērķis ir ļaut klausītājiem labāk izprast Eiropas Savienības tiesu un tās darbības pamatprincipus. Kā parasti vieslekcija arī šodien ilgs 2 stundas bez pārtraukuma, un tās beigās mums būs neliela jautājuma atbilžu sesija, kuras ietvaros jūs ap 30 minūtēm, kuras ietvaros jūs varēsiet profesoram uzdot jūs interesējušas jautājumus par šodienas lekcijas tematu, kā arī, principā, jebkurus citus jautājumus, kas jūs interesē. Es ceru, ka tomēr Brexit nebūs vienīgā tēma, par ko mēs šodien runāsim lekcijas beigās. Latvijas Tiesību institūta vārdā vēlos pateiktos par atbalstu šīs vieslekcijas sarīkošanā Latvijas Republikas augstākajai tiesai, Latvijas zierināta advokātu kolēģijai, konkurences padomei, jurista vārdam un Rīgas latviešu biedrībai. Un tātad, dāmas un kungi, man ir tas gods stādīt jūs priekšā profesoru Francisu Džeikobsu ar vieslekciju Eiropas Savienības tiesas darbību ar sevišķu uzsvaru uz prejudiciāliem jautājumiem un miedarbību ar nacionālām tiesām. Un lūdzu sveikt profesoru ar aplausiem.
Well, thank you very much for your introduction. I can't say your kind introduction because I wasn't able to follow it, but nonetheless, thank you very much. And thank you very much for the invitation to address this audience in this very remarkable building in this wonderful city. It's really a great pleasure for me to be here. It's long been an ambition of mine in any event to visit Riga, and I'm delighted to have the opportunity to do so in this particular context. I've always wanted to come to Latvia partly for historical reasons, which I will mention in the course of my talk. And I also appreciated recently in London the remarkable culture in Latvia, and especially its classical music. Enjoying in London concerts by outstanding Latvian musicians and operas with outstanding Latvian performers. On the academic side, I'm especially pleased to be contributing with this lecture to an emerging tradition of a visiting lecture from King's College London, first by Professor Richard Wish and then by Professor Alison Jones from my law school, which is now the Dixon Poon School of Law at King's College, where the Centre of European Law has been active for more than 40 years. I must also mention that it has been a great pleasure to have the remarkable assistance of Edis in making the arrangements for this visit. For the subject of my lecture today, I've been asked to focus on the system of references by the national courts to the European Court of Justice, as I'll refer to it. And I'm asked to draw in particular on my own experience as an Advocate General of the Court. And the subject of references for preliminary rulings is indeed a subject of central importance, and it happens also to have been a special interest of mine, because my work on this subject goes back quite a long time. I had the benefit of being the first British referendaire, or law clerk as it's sometimes called, assistant to a member of the court when the UK joined the European Community as long ago as 1973. I was the law clerk then to Advocate General Warner. We had a visit in the early days from a party of judges from the United Kingdom, including Lord Denning, who is quite well known outside the UK, a great judge in his time. And we explained to them how the system worked. They were very interested, and a colleague of mine who was the law clerk with the British judge at that time and I were explaining the system, and Lord Denning said, "You should write a book on this subject to explain it." So we did. We wrote a short book, References to the European Court, which was published about 40 years ago. So I am pleased to be looking back and talking about this subject today. And I will first of all look at the system of references in outline and how it works. Then I will focus on the general approach of the Court of Justice and the all-important role, as I think it is, the all-important role of the national courts in making the system work well. I'll put forward some suggestions of my own. I will discuss some recent criticisms of the European Court of Justice. And I will also talk about the important role played by judicial dialogue between the national courts and the European Court. I'll also give a brief account of the way in which the system of references has inspired attempts to introduce similar systems in other parts of the world. So I start with the system in outline. The system in outline is that any national court or tribunal can refer questions of EU law to the European Court of Justice, and the purpose of this system is to ensure that European Union law is applied in the same way across the whole of the European Union. That being especially important given the different languages that we have, the different legal systems that we have, the different approaches to legislation and the interpretation of the law in different countries, and so on. It's not perhaps very clearly stated, but I think it is clear from the wording of the treaty, which says that the Court of Justice shall rule on the questions referred by the national courts, that the court which refers the question must apply the interpretation given by the Court of Justice, that is, the ruling of the Court of Justice is binding on the court which made the reference. And I think it can reasonably be inferred from the purpose of the procedure, and the purpose is to secure uniform interpretation. It can reasonably be inferred from that the ruling of the Court of Justice is binding also on other national courts if they are confronted with the same question. However, they have the option, if they think it desirable, of referring the question again if they think that the Court of Justice, on reflection, might give a different answer. Otherwise, the ruling given by the Court of Justice must, I think, be regarded as binding on all national courts and tribunals confronted with the same question. Most questions are concerned with the interpretation of the treaty or of measures taken under the treaties. It's also possible for national courts to refer questions on the validity of EU legislation if it is argued that a particular provision of EU law is invalid. The position there seems to be clear, although again it's not explicitly spelt out in the treaty, that only the Court of Justice can declare an EU measure invalid. It is not open to national courts to decide that an EU measure is invalid. Again, that of course would threaten the uniformity of EU law if it were declared invalid in one member state but not in another. So that is a situation in which the national courts are limited, and if they consider that a measure is invalid, they should invariably refer that question to the Court of Justice. Again, I will say a little bit more about that procedure later. On the procedure itself, I can be quite brief because the procedure itself is rather brief and rather straightforward. When a reference is made to the Court of Justice, the National Court should set out in its reference the facts of the case, the relevant law, normally the relevant EU legislation and the national legislation, and perhaps also the National Court's own view as to the correct answer to be given to the question, because it may be helpful both to the Court of Justice and to those taking part in the procedure subsequently to know what the position of the National Court is on the question. Again, I'll expand a little bit on that. The reference drawn up by the National Court, once received by the Court of Justice, is translated by the Court of Justice into the other EU languages, now no fewer than 24 languages. And if the reference is too long, then a summary of the reference will be translated. This is partly because of the concerns over the length of proceedings. Because the reference from the National Court is simply a step in the proceedings in the National Court, and the proceedings are being held up by the reference, it's considered desirable that the answers of the Court of Justice should be given as soon as possible. And the time concerns are reflected in the procedure, which set a period of 2 months in which the written observations of those interested must be submitted to the court simultaneously. That is to say, the parties to the case in the National Court, the member states, all of which have the right to present observations, and the EU institutions, which are also entitled to present observations, must all do so within a period of 2 months. And there is no opportunity to reply in writing to the observations submitted by others. If that were done, it is considered that would delay the procedure unacceptably, and again, because the proceedings are being held up in the National Court, it's desirable that they should not be delayed excessively. So any reply to the written observations has to be made at an oral hearing an oral hearing before the Court of Justice in which the same parties, the member states, the institutions, are entitled to present their arguments orally. That is now a step which is taken only if good reasons for hearing are put forward. And under the current rules of procedure, the court may decide not to hold a hearing if it considers that it has sufficient information to give a ruling. That does not apply, however, if a request for a hearing is made by an interested person who has not submitted written observations. So if, for example, a member state, on reading the written observations, considers that it is necessary to advance argument at the hearing, it would be entitled to ask for such a hearing. So at the hearing, all those entitled to present arguments, whether or not they have submitted written observations, can present brief oral argument. That is not intended as an opportunity simply to repeat what they have already put in writing. That will be regarded by the court as unnecessary, but to advance essentially new points or points in reply to what has been put in writing by others. And there is then an opportunity for a brief reply at the oral hearing, and then for questions to be put by the judges and the Advocate General. After the close of the hearing, the Advocate General fixes a date for the delivery of the opinion. And I will say just a few words about the position of the Advocate General. The term is rather misleading, of course. The Advocate General is not an advocate nor a general. And to paraphrase the treaty, it's the duty of the Advocate General, acting with complete impartiality and independence, to deliver an opinion on cases where an opinion is considered necessary. There used to be an opinion of the Advocate General in every case before the court. But the statute of the court now provides that where a case raises no new point of law, the court may decide, after hearing the Advocate General, that the case shall be determined without an opinion. And I think it is perhaps no secret to say there may sometimes be a difference of view between the judges and the Advocate General as to whether an opinion is necessary. It may be that the Advocate General considers that an opinion is necessary and the judges perhaps consider that it is not, or the other way around, as you can imagine. However, I think in most cases there is no difficulty in reaching a satisfactory answer to that issue. The opinion of the Advocate General is not, of course, binding on the court. The judges reach their own conclusion and they decide the case in their own way, in their judgment. But it is generally considered that the opinion of the Advocate General is followed by the court in whole or in substantial part in a fairly high proportion of cases. In any event, as Professor Hartley has said rather reassuringly, the opinion will be considered with great care by the judges when they make their decision. The full text of the opinion is published together with the judgment in all the official languages in the law reports of the court. Those who follow closely the development of EU law sometimes suggest that even where the court does not follow the opinion of the Advocate General in the instant case, the court may subsequently develop the law in that direction. As Professor Hartley points out, and it's useful I think for me to have a neutral voice on this question, impartiality and independence are important characteristics of the Advocate General's office. He represents neither the Union nor any member state. he speaks only for the public interest. Or, as I'm almost tempted to say, he speaks only for the law. Professor Hartley also takes the view that an Advocate General's job must in many ways be more satisfying than that of a judge, and he gives some interesting reasons why that is so. I don't think I can comment directly on that point, not having been a judge at the court, but I can say that I did find the job extraordinarily interesting, but also, of course, extremely challenging, in part precisely because it is the Advocate General who always has to go first. And also, of course, because of the very wide fields of law in which the Advocate General may be required to pronounce, vast areas of EU law as they now are. And of course, it is difficult to have the necessary expertise in all of those fields. I'd also like to say something about the languages of the court and the language regime. Again, the court is obliged formally to use all the official languages of the Union, the current 24 languages. But in a reference, the language used is, in principle, the language of the referring court. So if a case is referred from a Latvian court, the reference is made in Latvian. Latvian is the language of the case, as it's called, the language of procedure. However, there are exceptions to this rule. Member states, for example, may use their own language before the court. Judges and the Advocate General may put questions in their own language. And nowadays, the Advocate General is likely to prepare the opinion in one of the 5 languages which are known as pivot languages. That is to say, English, French, German, Italian, and Spanish. The purpose of that is that if the Advocate General were to deliver the opinion in what might be called minority language, it would then probably have to be translated twice, once into a pivot language and then from the pivot language into the language of the case. That would lead to very substantial delays because it can take a month to translate an opinion with the quality required. And of course it would also increase the opportunities for errors in translation if it were translated twice. So the practice is, where possible, for the Advocate General to use one of the 5 pivot languages. However, the judgment of the court will normally be drafted in French. French has been, since the court started work in 1952, the sole working language of the court. Not the official language, but the working language. The use of French as the court's working language does seem increasingly questionable, but this, of course, is a somewhat sensitive topic. My own view, to the extent that I can express it, is partly a personal one, in the sense that I'm extremely fond of the French language and have been used to working in it to some extent, although, of course, I was able to prepare my opinions in English. I think it has to be recognized nowadays that English is increasingly the lingua franca in Europe. I read recently that no fewer than 97% of school children in Europe learn English as a second language. That may be an exaggeration, but it is clear that English is widespread, and it is also the case that it has become the main working language of the other EU institutions, and indeed of virtually all European organizations. While the subject of the working language of the court is a very delicate one, especially for an Anglophone perhaps, It has been aired by a former colleague of mine of the Court of Justice, the judge from the United Kingdom, Judge Sheeman, in an article which he contributed, which was written in French, I hasten to say, in a contribution to a book published in honor of the President of the Court, Vasilios Skouris, on his retirement from the court last year. Judge Sheeman wrote this book, this article, La langue de travail de la Cour, in which he raised the question of the working language of the court for the future. I mentioned briefly some of the concerns over the use of the French language. First, it limits the choice of recruits to serve as members of the court, because it is obviously desirable that the judges should have an extremely good knowledge of the working language. And second, it limits the choice of the law clerks, those who assist the members of the court, and especially, perhaps, the law clerks of the judges, because they must be able not merely to speak French, but also to assist with the drafting of the judgment in French. And this, it is said, may result in a high proportion of law clerks being products of certain systems of law, and thus give those systems a disproportionate influence in the development of EU law. If English were the working language, there would probably be a far wider spread of law clerks. And a third point is that the use of French as the working language of the court may make it more difficult for judges in their deliberations to express themselves fully, and therefore to take an effective part in the roundtable discussions, which must play a crucial part in the making of judgments. You might think it a little paradoxical if English were to become the working language of the court if the United Kingdom were to leave the European Union. However, there is, of course, the example of the EFTA court, the court which is responsible for the implementation of the EEA agreement, where the member states are Norway, Iceland, and Liechtenstein, but whose working language, and for some purposes even official language, is English and not the language of any of the member states. So I just want to mention briefly, without developing them, a number of other procedural points before I turn to the question of dialogue with the national courts. First of all, I would like to mention that the court has published a very helpful set of recommendations, in case you have not come across this, designed specifically for the benefit of national courts, but also, of course, of great value for national practitioners who may be concerned with references to the Court of Justice. This set of recommendations started life quite modestly many years ago as simply an information note on one page. It's now quite a substantial publication in the official journal of the European Union. It was published, in fact, in the issue for the 6th of November 2012, Recommendations, Court of Justice of the European Union, and it's entitled Recommendations to National Courts and Tribunals in relation to the initiation of preliminary ruling proceedings. So there's much useful information and guidance in those recommendations on the practical side of references. I ought to mention, simply because it might arise, that there are two special procedures where there is particular need for speed in getting a ruling. There is a procedure called the expedited procedure, and there is another procedure called the urgent procedure. These are two separate procedures. One is particularly rapid, and the other is extra rapid. They involve eliminating many of the phases in the normal procedure. And I don't think I need to discuss them in any detail, because it may never arise for your purposes. If it does arise, they're very clearly explained in the recommendations in the official journal, which I have mentioned. So I now turn to the question of the dialogue with the national courts. And as it seems to me, and others have taken the same view, the national courts do have an absolutely key role in the system of references. And this is something which I hope will be borne in mind by national judges and by practitioners appearing in cases referred to the Court of Justice. I would suggest that they can do a great deal to assist the Court of Justice in a number of ways. They can contribute to improving the way in which the system works, the way in which the reference system works, and indeed they can contribute, as I see it, to the quality of the resulting product, the case law of the European Court of Justice itself. They can assist, I think, in three principal ways. First, in taking the decision whether to make a reference at all. Second, if they do make a reference, in considering at what stage the reference should be made. And third, in the way in which the reference is made and presented to the Court of Justice. In deciding whether to refer, the first question, the national courts have a discretion whether to refer or not. In some cases, they have an obligation. Essentially, the treaty provides for a discretion of the national court, except for final courts, courts of last instance, which have an obligation to refer. Now, in exercising the discretion to refer, the national court, it seems to me, should reflect carefully. It's obvious that a reference should not be made automatically simply because there's a question of EU law. This is a question of EU law, so it should go to the European Court. That is a view which has sometimes in the past been taken by national courts. It should also, I think, not be seen as simply a problem-solving exercise, a means of resolving difficult issues. There may be difficult cases which should be referred, but there may be difficult cases which should not. One should not take the view, this is a difficult case, so it should go. It seems to me the best guide, as so often with the law, on questions of interpretation, how do you interpret this provision which says the national court may refer? How do you interpret the discretion? Is to consider the purpose of the system, and the purpose of the reference system is, as I've said, essentially to ensure that EU law is uniformly applied. So I think we could go further, as I've in fact argued for a long time, and say that a reference is most appropriate when a ruling by the European Court of Justice is necessary or useful. Necessary or useful not merely for the instant case, but for the application of EU law more generally. And that is not always the situation. For example, it's not the situation if the legislation in question has long expired by the time the question arises in the national court, so that a ruling might be relevant only in the instant case and of no further use beyond that. In that situation, the case for a reference is much less strong. There is also, at a more mundane level perhaps, areas where it may not be particularly appropriate for the European Court of Justice to be the arbiter. If you take an example of the classification of goods under the EU customs tariff, what used to be called the common customs tariff, and is now called the TARIC, the Integrated Tariff. There are perhaps better ways of resolving such disputes. The Commission has a procedure for dealing with that, for example. And it's a highly technical field in which the court has no particular expertise. Almost by definition, it will concern a different kind of product from one that has been considered before, and the difficulties are of a technical character where the court is not best placed to find the right answer. I once suggested many years ago in an opinion in a case before the European Court of Justice that the court was not best placed to rule on an issue concerning the customs classification of women's night dresses. That was a case called Vina. There was an issue there as to whether something could be classified as a night dress if it were worn occasionally also during the day. And that was an issue that the court was asked to address. I sought to suggest that there should be a more considered approach to references generally. And I think the ideas received a favourable echo in the court, although of course the court didn't formally endorse the idea in its judgment. That is not how the court works. But I do think that the national courts generally are now being more careful in exercising their discretion. Not only in customs classification cases, which are actually now rather rare in the court, but also in other areas too, where similar considerations may apply, and the Court of Justice may not be the best place to go to get an answer. Anyway, I did notice that English courts occasionally referred to my opinion in the Wiener case on night dresses in later cases which they had, perhaps in cases where they, for one reason or another, they did not want to make a reference, and they were pleased to find some support for thinking carefully before referring. Now, when it comes to the obligation to refer, the obligation of the final courts, such as the Supreme Courts of the member states, although there is an obligation in the treaty there, it says the court of last instance shall refer. In my view, that obligation should also be considered very carefully. I don't think the obligation should be taken too literally. If it were, the Court of Justice would be swamped and overrun and simply unable to carry out its tasks. So some form of selection may be necessary. I would not favour the approach which was expressed by one judge from the Supreme Court of another member state when I was chairing a panel of judges from different countries discussing the obligation to refer. That judge, speaking of his own Supreme Court, said, obviously we cannot have an obligation to refer every case. We have far too many cases. So he said, which cases do we refer? Well, of course we refer the cases where we already know the answer. If we did not know the answer, how could the European Court know the answer? Well, that again did not seem an entirely satisfactory approach to the question, and it seems to me again that the purpose of the system is really the key to the answer. Equally, in the case of a Supreme Court, a reference is going to be more useful where the provision in question is a provision of general application, where a uniform interpretation will therefore be important. Or perhaps where a ruling by the European Court will be particularly important for the Union itself. So one sees, I think, some movement in that direction. And I was pleased to find that when the Court finally published its recommendations that I've referred to on references, the Court has in that document indicated that one of the important considerations for the National Court in deciding to make a reference is the purpose of the system and the importance of the uniform application of EU law. So I think that is more widely recognized today. I'd also add, more generally, this may not be a matter for the national courts to consider in making a reference. It may be useful to add that it will be desirable to have a limited number of cases before the European Court of Justice in order to ensure that the court can maintain the quality of its case law, the consistency of its case law, and indeed, I would say, even the accessibility of its case law. Because if it gets too many questions, that will threaten the quality, the consistency, and the accessibility of the court's case law. And it's noteworthy that in recent years, there seems to have been a very significant increase in the number of references to the court. I followed these statistics for quite some years, and remarkably, for a period of 15 years, down to 2008, the total number of references from all courts in the European Union was stable at between 200 and 300 references a year. That seems statistically rather remarkable that the number should be so consistent. It may almost have seemed that some invisible hand was at work. Latvia has made a significant contribution in relation to its size, a total down to 2014 of 21 references from the Supreme Court, which is a relatively high number for a Supreme Court in relation to population, and 16 references from other courts and tribunals, making a total of 37 references in all down to 2014. But last year, 2015, was marked across the European Union by what is described in a press release from the court as an exceptional rate for the court's judicial activity. Last year, a total of 1,711 cases were brought before the three courts comprising the judicial institution: the Court of Justice, the General Court, previously known as the Court of First Instance, which does not deal with references, and the Staff Tribunal. And of those 1,700 cases, more than 700 new cases were brought before the Court of Justice, the highest annual number of cases in the history of the Court of Justice, including 431 references for a preliminary ruling, a very substantial increase from the 200 to 300 umbrella of previous years. So this has not so far had a significant effect on the duration of proceedings. The duration of proceedings in 2015 has statistics which are described in the court's press release as very positive. The average time taken to deal with references was 15.3 months, very close to what is described as the record figure of 15.0 months in 2014. I have to confess I'm not so really concerned with the statistics about the duration of proceedings. I think that there has been a concern in recent years to try to speed up the delivery of judgments. But there is also, of course, the concern to maintain the quality of judgments. And excessive concern with speed may be damaging in other ways. So I think we ought to be aware of the need to relieve the burden on the Court of Justice. As I have suggested, one of the ways of doing that is to reflect carefully on the desirability of a reference. Certainly, of course, to continue to make references in important cases, but not perhaps to make references in cases where the value is not apparent. There may be other ways of relieving pressure on the Court of Justice. But if one looks at those carefully, one sees difficulties really with all of them. One suggestion, which might seem the obvious one, would be to increase the number of judges and perhaps advocates general. But that would actually be a recipe for a disaster, as I think, in the Court of Justice, because the attitude of the member states to any increase in the number of judges would be that the number would have to be doubled, because no member state would be willing to forego having a second judge. So the court would go from 28 judges, one per member state as at present, to 56. Well, with enormous difficulties about managing such a large number of judges as to maintain, for example, consistency in the case law. And that is precisely what is now happening over an extended period at the General Court, the former Court of First Instance, where the number of judges is being increased over an extended period from 28 judges, which was considered too few, to 56 judges, which seems certainly excessive. So, one of the most obvious ways of coping with an increased caseload of the Court of Justice is really not the right solution. And a second solution, which would be to transfer more cases to the General Court, where they will have more judges to deal with cases. Transferring more cases to the General Court is also fraught with difficulties. There are basically only two types of case that could be referred to the General Court. One would be certain categories of references from the national courts for preliminary rulings. And there is a provision which has not been activated, which would allow for transfer of cases to the General Court, enabling it to give preliminary rulings in some categories of cases. But the difficulty is to decide which categories of case would be suitable for transfer. And that's a question to which it's very difficult to find a good answer. Some would say, again, well, we could refer technical cases, like cases about the common customs tariff, the tariff, to the General Court. But then one thinks of some of the cases which have arisen there. There was a case many years ago called Van Genden Loos, which concerned tariff classification and resulted in one of the most important cases, perhaps the most important case, which the court has ever decided, the case of Van Genden Loos in 1963. So it is difficult to identify categories of cases which can be referred to the General Court. And the other main category, which could at least theoretically be transferred, is cases brought by the European Commission against member states, where the Commission considers that the member state has infringed the treaty. Those cases could be transferred to the General Court with the possibility of an appeal to the Court of Justice. But again, of course, they range enormously in their importance. There are some which are very trivial, failure to implement a technical directive in a particular field, and there are some which are of great constitutional significance. So it is really, again, difficult to find a general criterion which will be satisfactory, even if it could be thought that the member states would be willing to have those cases transferred to the General Court, because they would have to agree to that. So I don't think there is a totally satisfactory solution to the question of relieving the pressure on the Court of Justice. But as I've suggested, I think one way in which one can relieve the pressure is to try to ensure that the right cases are referred. That does not necessarily mean, of course, a decision not to refer. It may well mean, in some cases, a positive decision to refer rather than leaving the National Court to decide the point itself. But a more considered approach to references would be very valuable. I would also mention that while there should be caution in deciding whether to refer, the European Court of Justice is ready to answer questions wherever possible. It is predisposed to accept references in areas where it might, strictly speaking, take a different view. For example, it is keen to ensure that national provisions are interpreted consistently with European law provisions, even if the European law provisions are not directly applicable. And there was a very good example of that in a recent reference from the Supreme Court of Latvia, a case which you may know, which is SIA Maxima Latvia, case 345-14. The Supreme Court referred questions on whether certain restrictions in agreements for the lease of commercial property rendered such agreements anti-competitive for the purposes of Article 101, Paragraph 1 of the treaty. Were those restrictions anti-competitive for the purposes of the treaty? And the Supreme Court, in making the reference, pointed out that it was common ground between the parties that those agreements were not of a kind that could affect trade between member states. So, on the wording of Article 101 of the treaty, they would not be within that article. However, the Supreme Court took the view that the wording of the Latvian law on competition was similar to that of the treaty, and that Latvian law should be applied in accordance with the requirements of EU law. The Supreme Court also observed that there was a clear interest in having a uniform interpretation of the provisions and concepts of EU law. And the European Court of Justice accepted the reference and duly answered the questions referred. The second question, which I will deal with more briefly, is if a reference is to be made, at what stage should the reference be made? At what stage in the proceedings before the national court? Or should a reference generally be left to an appeal court? Well, very briefly, I can refer you again to the recommendations to the to national courts which the Court of Justice has issued. I think it's difficult to give a general answer to these questions, but I would suggest, and the recommendations are on the same lines, that a reference will come best when the issues before the national court and the implications of the answer to be given can be clearly understood. In other words, in general, it will be helpful to refer once the relevant facts have been established and once the national court has heard argument on EU law and has perhaps formed its own provisional view of what the answer should be. And this aspect is closely related to my third question, the way in which the reference is made, how it is to be formulated, what it is to include. A reference may be less helpful if it merely outlines the facts and then says on the law, the claimant contends X, the defendant contends Y. It would be more helpful if the reference is framed to take account of the arguments that have been advanced on the EU law point. And maybe the national court, as I've suggested, has formed its own provisional view on the answer to the questions, a view which the national court could set out in the reference. This will be helpful, of course, not only to the Court of Justice, but also those presenting observations to the European Court of Justice. Because if the reference is rather skeletal in its formation, it would be very difficult to know what issues should be addressed in the observations, and that in turn will be less helpful to the Court of Justice in reaching its judgment, may even result in the judgment going down the wrong track. If the National Court does set out more fully the issues of EU law and perhaps its own view of the answers, then that may enable the Court of Justice to understand more fully the concerns of the National Court and the substance of the issues, and will assist those presenting the observations before the Court, which is particularly important because of the very limited opportunities, as I've outlined, which the procedure before the Court of Justice gives. The very abbreviated procedure makes it important that from the outset, those addressing observations to the Court should know what is at stake. I would suggest, therefore, that national judges and lawyers who are assisting the judges in the formulation of the reference should not think that certain matters can be omitted because they can be addressed when the case goes to the Court of Justice. That may be too late and will certainly not give a full opportunity for an exchange of argument. So I would suggest that the time has come when national courts, with their increasing expertise in EU law and with the maturity of the EU legal system itself, should perhaps set out the reasons for their decision to refer, and should also, as some already do, include in their reference to the Court of Justice their own provisional views on the answers to the questions. There's an additional advantage if the National Court does that, because it might show how the answer would fit in with the national legal system. It could also encourage the Court of Justice to be somewhat more flexible in its response, which may be desirable if it's apparent that some variation in the answer may be appropriate among different legal systems. Well, I have quite a bit more material to cover, but I have been going for an hour, and I just thought it might be useful to see if there are any immediate questions which you may have on the topics which I have covered so far in relation to the purposes of the system, the procedure before the European Court of Justice, and the approach to be taken by the national courts, and so forth. If you have any immediate questions that you would like to put, because I know sometimes if one gets to the end of the lecture, the moment may have passed, or there may be other things which seem more pressing. If anyone has any questions at this stage, I'd be happy to try to answer them briefly before moving on. No, it seems there are no pressing questions at this stage, so I can take that in one of two ways, I suppose. So I will continue then, and what I would like to do now is to look ahead and suggest a way in which some of the ideas I mentioned already could be taken a little bit further. I'm coming to say some words about what is called, it's not my own invention, this procedure, what is called the green light procedure. Looking ahead, in my personal view, the idea of giving the national courts a bigger part in the process could be developed by what is called the green light procedure, in which, where the national court has set out its own provisional view on the answers, the European Court of Justice, instead of giving a ruling in the usual way, could, in appropriate cases, but certainly not in all cases, but could in appropriate cases give what is called a green light. That is a signal that the national court could apply its provisional answer. That would not imply that the Court of Justice explicitly endorsed the view of the National Court, but only that it did not regard the view as, at the current stage, open to significant objection. If that system were to operate in appropriate cases over a period of time, it could, I think, have substantial advantages, because it would make it possible for the Court of Justice to answer cases on a more selective basis, answer cases where the issues were sufficiently important, but also where they were ripe for judgment, because it may be that the court is sometimes asked to rule on questions which are not really ready for judgment. I could give some examples where that has, in my view, happened. The Court of Justice has considered itself compelled to answer a question where further developments in the law might have been preferable before the court came to a ruling. I'll mention simply one case where that seems to be the case without elaborating on it. Some of you will know it because it has had a great deal of publicity, and that is the case known as Google Spain, where the court was asked a rather difficult question at a rather early stage, and in the view of some, there would have been benefit in waiting rather than answering the question straight away. That would enable the court then to focus on cases which were really ready for judgment, and perhaps on cases which were particularly important for judgment, and perhaps to decline to rule in other cases where the provisional view of the National Court seemed perfectly acceptable, without the issue, therefore, in that case, being definitively decided. From my point of view, there would be no great harm in such a process. I think the idea would have a number of advantages as the number of cases grows, because it has the advantage that it would preserve the right of all courts to continue to refer questions to the Court of Justice, even if in some instances that those courts did not get a ruling from the court. The alternative in time might be that the number of courts entitled to refer would have to be limited in some way in order to keep numbers down. But I also think that the procedure might have other advantages, both for the Court of Justice and for the national courts. For the Court of Justice, of course, it would alleviate the growing burden, and so might enable the court to cope with an increasing caseload without sacrificing quality and still deciding cases within a reasonable time. And it would also perhaps make it unnecessary to adopt other solutions which might be unsatisfactory. I've mentioned, for example, a substantial increase in the membership of the court, or the transfer of references to the General Court, which do not seem satisfactory solutions. I think it would also make it possible for cases to be decided by a larger number of judges, and perhaps therefore a more representative court, and therefore for judgments to perhaps to be a little bit less hesitant than they may sometimes be now, or possibly inconsistent, and carrying more authority. It's a change which I think could also be done without amending the treaty. The fact that the Court of Justice has jurisdiction to rule on references from national courts does not, I think, mean that the court is obliged to rule on every question which is referred. It would also avoid a proliferation of excessively detailed and perhaps increasingly complex case law, which may become, in the longer term, almost unmanageable for the user, and perhaps even difficult for the court itself, because it would lead to a smaller number of judgments on perhaps more significant issues. But also it would have advantages in that it would leave national courts free to develop alternative lines of case law, because they may have different views on what the answers are. That actually could be quite a positive development. If the national approaches diverged too much, and if uniformity was truly important, then of course the Court of Justice could intervene at any point in a subsequent reference, or, if necessary, the legislature could intervene to amend the legislation and so clarify the particular issue and remove the divergent approaches. A final incidental advantage of that system is that the national courts across the member states would have access to information where the Court of Justice did not give a ruling about the approach taken by courts in other member states, because the references from the other courts would be available on the court's website and would be available in the different EU languages. So there would be some elements also of cross-fertilization. And this, of course, would give national courts a greater role in the development of EU law. Even if we don't go down that road, if we don't adopt the green light procedure, there is, I think, still a great deal which national courts can do to develop a dialogue with the European Court of Justice, to assist the court in its tasks, and to contribute to the improvement of the system, and to contribute to the improvement of the resulting case law. And I would like to say a word also about how this positive contribution from the national courts can come even where they challenge what is being done by the Court of Justice. That, of course, is a particularly significant development in recent years, where there has been increasingly some element of challenge from the national courts. I think that too may have very positive aspects. I'll give one or two examples. If you look back on the history of the European Union, you find that from the outset almost, there have been occasional challenges from the national courts, and especially by the Supreme Courts and constitutional courts of the member states. One particular aspect of this is the rather special role of national constitutional courts, which may not be important here or indeed in a number of other member states which don't have specialized constitutional courts. But where there is such a court, its role has often been a somewhat difficult one, in that it may regard its functions as limited to interpreting the national constitution and not as having a special role in relation to EU law, although occasionally, of course, it has led to challenges. Constitutional courts were exceptional in Europe in the last century. The first, I think, was introduced in Austria, and then they were established in Germany and Italy after World War II. Most recently, they've been established more widely, notably in many of the newly liberated states of Central and Eastern Europe, where the establishment of a constitutional court made possible, as it may have been thought, the infusion of new judicial talent. But they are now also found in other EU member states, Belgium, Spain, France, so they now exist in a majority of member states, but not in practice in most of the northern and northwestern member states of the European Union. On one view, their special role has meant that they do not use the reference procedure because their task is limited to interpreting the Constitution. And for many years, there were in fact very few references from national constitutional courts. But they also see themselves as having a special role in protecting their constitution against external encroachment. The leading example is, of course, the German Federal Constitutional Court. In the early years, it played what is, I think, a positive role by expressing concerns, without making references to the Court of Justice, that EU law might not adequately protect fundamental rights, as understood under the German Basic Law, and so the possibility that some aspects of EU law could not be applied in Germany if they were to infringe fundamental rights. That was purely a theoretical concern, but it led the Court of Justice to develop its own case law quite significantly. As long ago as 1970, in a famous case called Internationale Handelsgesellschaft, the Court of Justice definitively changed its case law to recognize a more important role for fundamental rights in European law. And since that time, there have been developments of particular interest in the field of fundamental rights. And the Court of Justice has had difficulty, I think, in reaching the right level of protection. There has even been a case involving Latvia, quite a famous case. There were two cases, Viking and Laval, and they were concerned essentially with the conflict between fundamental rights on the one hand and the fundamental freedoms, the fundamental economic freedoms of the treaty on the other. So that in Laval, the question was whether a company could avoid a collective agreement in Sweden by using a Latvian organization. And so the question was the balance between, on the one hand, fundamental rights of free association in trade unions, on the one hand, and freedom to provide services and freedom of establishment, the economic freedoms of the treaty. And in the Viking and Laval cases, the court took what was inevitably a controversial position. It seemed to give preference to the fundamental economic freedoms of the treaty. There was another case which I find quite intriguing, where there was a conflict between fundamental rights and the fundamental freedoms of the treaty, which was the case of Omega. Omega was a case referred by the German courts because there was concern in Germany about a sport consisting in a game in which there were laser guns to be fired at mock human beings. This was a rather strange sport, but apparently was practiced in certain member states of the European Union, and the products in question were imported from the United Kingdom. But the German authorities took a different view. They regarded the practice of firing to kill dummy human beings was an affront to human dignity, contrary to the fundamental rights guaranteed by the German Basic Law. And they referred to the Court of Justice the question whether the German authorities were entitled to ban that practice, even though it involved limiting the freedom to provide services and the free movement of goods. So again, a clash between fundamental human rights and the economic freedoms of the treaty. And in that case, the Court of Justice took the view, which was really quite out of line with some of its earlier case law, in which it not only accepted the right to ban this particular exercise in one member state on grounds of fundamental rights, but also accepted that fundamental rights could be differently understood in different member states. That was a rather unusual ruling, I think in two respects perhaps. First of all, the court had always been extremely strict about allowing exceptions to the free movement of goods and the freedom to provide services. And secondly, of course, it was always primarily concerned with the uniform application of EU law across the entire EU. So to allow a particular exception, as it appeared, for German concern over fundamental rights seemed to be rather unusual. So that was the Omega case. And I was reminded of the Omega case when I read in yesterday's London Times a letter which happened to be published yesterday, which it's very brief and I must read it to you. It says, "Sir, my sons have long since grown up, left home, and now have families of their own. But I still have a cupboard filled with their old toys and games. And looking through it recently, I found a board game in a large black box entitled Stop Boris. Boris being a large menacing spider whose progress can only be halted by a ray gun." And then the letter ends, "Any offers." Well, I thought that was somehow a coincidental reference to the Omega judgment, but also of topical interest. Returning to the role of the constitutional courts, I should mention briefly, I think, a recent potential conflict between the German Constitutional Court and the Court of Justice in relation to the financial crisis. And this concerned the activities of the European Central Bank. You may know the background to this from your reading of the press, but essentially, in the most acute phase of the euro crisis in 2012, the European Central Bank introduced what was called the Outright Monetary Transactions Programme, under which the European Central Bank was prepared to buy unlimited amounts of government bonds, subject to certain conditions. That promise of intervention by the European Central Bank apparently convinced the markets that there was little risk now to the survival of the euro. But the program was challenged before the Federal Constitutional Court in Germany by Mr. Gauweiler, and the court referred the issue to the European Court of Justice. Incidentally, the first reference that the Constitutional Court had ever made to the Court of Justice. However, at the same time as making the reference, the Constitutional Court followed the practice, which I have suggested as a valuable one, of indicating its own view. However, it seemed to indicate its own view in such a way as to suggest that that was the answer to the question. And really, the reference appeared to be, in a sense, a challenge to the European Court of Justice, because the Constitutional Court had taken the view that the program was unlawful. The European Central Bank, according to the Constitutional Court, had exceeded its powers and had also violated the prohibition of central bank financing in the treaty, Article 123, paragraph 1. So the reference was apparently designed not to request an answer from the European Court of Justice, but almost, as it seemed, rather to give the European Court of Justice the opportunity to agree with the Constitutional Court's view. However, the European Court of Justice did not agree. It held that the European Central Bank had not overstepped its monetary policy mandate, nor violated the provision of the treaty. I have to say that in this case, the position of the Federal Constitutional Court did arouse some criticism and generated some controversy about its role in EU matters, where it has sometimes relied on the principle of democracy in limiting the competence of the European Union. There was a striking comment in the dissenting opinion in the Constitutional Court, the dissenting opinion of Judge Lubbe-Wolf. She said, I quote, that some few independent German judges invoking the German interpretation of the principle of democracy make a decision with incalculable consequences for the operating currency of the Eurozone and the national economies depending on it, appears as an anomaly of questionable democratic character. However, the reference went ahead. The Court of Justice declined to follow the view of the German Constitutional Court, and in its final response, when the Constitutional Court came to apply the decision of the Court of Justice in a judgment given last week on the 21st of June, the German court in the end fell in line with the Court of Justice. It said that if interpreted in accordance with the judgment of the Court of Justice, the policy decision on the OMT programme does not manifestly exceed the competences attributed to the European Central Bank. That was really the yardstick that the Constitutional Court had applied. If there was a manifest exceeding of the competence of an EU institution in a way in which the German court considered contrary to the democratic principles of the German Constitution, then the German courts should not apply it. But here there was no manifest excess of competences, and the second point was, if interpreted in accordance with the Court of Justice's judgment, the OMT programme does not present a constitutionally relevant threat to the German Parliament's right to decide on the budget. So, this is another illustration of growing challenges to the Court of Justice from constitutional and Supreme Courts, and other constitutional courts have recently followed similar lines, and so indeed have some Supreme Courts. Even the Supreme Court of the United Kingdom has recently embarked on some criticisms of the European Court of Justice, and has suggested that the United Kingdom Supreme Court might have a role in some ways similar to the constitutional courts of other member states. For example, a judge in the UK Supreme Court, Lord Reid, a Scottish judge, said in a lecture, not in a judgment, said in a lecture that the Supreme Court had a special role. It is important to remember, he said, that the entire edifice of EU law is constructed on the foundation of the national courts. It depends on the existence of an effective and independent national judiciary to ensure respect for EU law in each of the member states. It is the national court that hears the case, finds the facts, and applies the law, including EU law. The national court may, of course, refer questions to the Court of Justice for a preliminary ruling, but even then, it is the national court which applies the answer to the referred questions and decides the case. In carrying out its functions as the highest appellate court of the United Kingdom, the Supreme Court, he said, is, I believe, as conscious as ever of the importance of maintaining a cooperative relationship with the Court of Justice, but it is also conscious of its own responsibility to uphold our Constitution. The role of the Court of Justice in securing the implementation of EU law at the national level is not in doubt. The reciprocal role of national courts in patrolling the limits of EU law should, I think, be regarded, in the parlance of 1066 and all that, as a good thing. It helps to ensure that national constitutional principles are respected, and may also help to foster the sense that domestic and supranational courts are all part of a European legal community, a collaborative rather than a hierarchical or competitive relationship between national apex courts and the Court of Justice can involve delicate and complicated issues. These issues have to be addressed in a spirit of cooperation and respect, and with an awareness of each court's respective responsibilities. And so on. It's quite a long quotation. I won't read the whole of it. You will find it in Lord Reid's Thomas More lecture given at Lincoln's Inn in 2014. I think the message is clear. But it's still, of course, open to question. When he talks about the role of the Supreme Court in patrolling the limits of EU law, that's really a rather difficult question. If each constitutional court or Supreme Court in the European Union takes on the task of patrolling the limits of European Union law, then there does seem to be some scope for divergence. And it's precisely in that area where it seems essential that there should be a single answer to the question of the limits of EU law. It has to be given, one would think, by the Court of Justice, but of course the Court of Justice has to respect the concerns of the member states and of the national constitutional and supreme courts. So there again, dialogue is essential, increasingly so, I think. I have said perhaps enough about the system of references for preliminary rulings, but I want now just to conclude by saying something about the way in which this system has been regarded around the world and taken to some extent as a model by other systems. And I would mention first, of course, the court which I mentioned earlier, the EFTA court. The EFTA court, which is set up to ensure compliance with the EEA agreement involving Norway, Iceland and Liechtenstein, where the EFTA court has a very similar jurisdiction to the Court of Justice. You may remember that many years ago, when that was set up, there was initially the idea that there should be a joint court for the EU and for the EFTA countries. That was turned down by the Court of Justice. They didn't want to have some of their judges sitting some of the time in the enlarged court. So a separate court was established for the EFTA countries, at that time including Austria, Sweden, Finland, as well as Norway and Iceland and Liechtenstein. The system of references for preliminary rulings works in exactly the same way in the EFTA court. Technically, the EFTA court does not give binding rulings, but only opinions. But in practice, its judgments are observed by the states concerned. And in practice, it follows very closely the case law of the Court of Justice. So it is a sister court, if you like, of the European Court of Justice. It has the huge advantage, working only, as I've mentioned, in a single language, of a very small staff. There are three judges in the EFTA court. There is a registrar and a very small staff, a dozen or so in all, based in Luxembourg, doing a very effective job, as I would assume. But there have been perhaps even more ambitious attempts to follow the example of the European Court of Justice and the system of preliminary rulings in other organizations around the world. To take very briefly three examples of attempts to follow the EU system. First of all, in Africa, there are, as you may know, several regional organizations of economic integration in different regions of Africa. And several of them have established courts closely modeled on the European Court of Justice. Perhaps the best known is the Court of the Common Market in Eastern and Southern Africa, which is called COMESA, Common Market in Eastern and Southern Africa. The COMESA Court has the jurisdiction to decide cases under the COMESA Treaty, and there was recently a case before the COMESA Court called Politol against the Republic of Mauritius, which is quite remarkably reminiscent of the Van Genden-Loos case that I mentioned earlier. In this case, Politol, the claimant had imported goods from Egypt on which Mauritius had imposed customs duties, contrary to the provisions of the COMESA Treaty establishing the common market in Eastern and Southern Africa. The customs duties were challenged before the COMESA court, and the COMESA court, citing the Van Genden-Loos case, held in its judgment, which was given in 2013, that the provisions of the COMESA Treaty in this respect had direct effect and that the customs duties were unlawful. A second example, mentioning again very briefly, was the Caribbean Court of Justice for the Caribbean community, the economic community also called CARICOM, which has set up a court in Trinidad. The Caribbean Court of Justice has two very broad heads of jurisdiction. First of all, it hears final appeals in civil and criminal cases for the states which have accepted its jurisdiction, largely where the states have previously had their appeals heard by the Judicial Committee of the Privy Council in London. Some of those states have now accepted the jurisdiction of the Caribbean Court of Justice. So there are final appeals in civil and criminal cases. Currently there are 4 states which have accepted that jurisdiction. But all of those states have accepted the jurisdiction of the Caribbean Court of Justice to give preliminary rulings on references from the domestic courts. The unfortunate thing is that there seem to have been virtually no references made under those provisions. So the provisions have been something of a dead letter. But the court is permanently established. It has this jurisdiction of an appellate kind, and no doubt in time there will also be increasingly references to the Caribbean Court of Justice. One can find, if one looks back at the European Union's history, that it took a very long time before national courts regularly accepted to make references to the Court of Justice of the European Community, as it then was. For many years, judges were very reluctant to take advantage of that procedure. And now we see it's flourishing and possibly even to excess. And my third example, which brings me really to Latvia, was an attempt to introduce a system based on the European Court of Justice in the former Soviet Union. It is rather a remarkable episode in the history of the Soviet Union when, in 1991, under President Gorbachev, the idea was to set up a community for what would be the former Soviet Union countries, in which there would be a court of justice, and the court would be empowered to hear references from the member states of the community. And it was remarkable at that time. There was a diplomatic conference. I had the extraordinary experience of being asked to speak and to explain how the system worked in the European Union. And at that time, even the Baltic states were interested in joining a new community with the former members of the Soviet Union, a community based on the rule of law. Sadly, the project came to nothing, and Gorbachev resigned, and as we know, the pursuit of the rule of law in the former Soviet Union has proved a very difficult course. But it's nonetheless a moment in history, perhaps to remember. We now have a body called the Eurasian Economic Union, which consists of Russia, Belarus, Kazakhstan, Armenia, and Kyrgyzstan, which does have a court, but I don't think one can say too much about the rule of law in those countries today. So, I think, again, that's an interesting example of the way in which these ideas have proved an inspiration for other continents. And, of course, one of the great achievements of the European Union has been in promoting the rule of law across the European Union. So that is one of the reasons why I think the subject of references from national courts is an important subject. It's part of building up a common approach, sharing legal experiences, developing common traditions, and I think it's played an important part in the evolution of Europe to date, and I hope will continue to do so in the future. Thank you very much for your attention.
So now it's time for any questions from the audience, if we have questions. Yes, please.
First of all, thank you for a very interesting presentation. For me, the preliminary ruling procedure was always fascinating regarding the obligation of Supreme Courts to make reference to the European Court of Justice. And the enforcement of this obligation was quite neglected some 15 years ago. And the last developments, starting with the Kobler case and now continuing with the European Court of Human Rights judgments in recent years, have put some pressure on national Supreme Courts. I would be really happy to hear some thoughts on your part about all this situation.
Yes, well, thank you very much. Indeed, that is a subject which I didn't address at all, and I think it is a very interesting subject as well. The idea that it may be necessary to enforce, in some situations, the obligation of Supreme Courts to make references, for example, when they have an obligation to do so under the treaty. They may not have failed systematically to carry out that obligation, but there may be some defects in their procedure. And again, I can take as an example the United Kingdom. In the United Kingdom, the Supreme Court has always operated on the basis that it has the power to select the appeals that it is going to hear. So there is a preliminary process, I'm sure many of you know, in which you have to apply for permission to appeal to the Supreme Court. You may get permission from a lower court, but normally the lower court refuses because the Supreme Court likes to have its own decision on the matter where possible. So normally, if you want to go to the Supreme Court, you have to apply for permission to appeal, and that results in appeals being quite limited in number. There are something like, very approximately, 100 appeals heard by the Supreme Court each year. Now, one of the issues was where a claim based on European Union law had been rejected by the lower court, we might say by the Court of Appeal, and the Court of Appeal had refused to accept the claim and had also not made a reference to the Court of Justice. Because it had not made a reference to the Court of Justice, it could only be assumed that the Court of Appeal did not regard itself as a final court. But what happened if the Supreme Court then refused permission to appeal? The position seemed to be that retrospectively the Court of Appeal had been the final court, and therefore a reference should have been made. So it could be argued in that situation that if the Court of Appeal had failed to make a reference, then there was a right to an appeal to the Supreme Court to avoid that consequence. However, in some circumstances, the Supreme Court rejected the application for permission to appeal. And that issue attracted the attention of the European Commission, and which took the matter up informally with the United Kingdom with a view to possibly bringing infringement proceedings against the United Kingdom. And one of the difficulties to defend the position of the United Kingdom in that situation was that the Supreme Court at that time didn't give reasons why it rejected the application for permission to appeal. So it was not clear on what basis the Supreme Court had taken the decision. And one could, of course, take the view that if there were good reasons for rejecting the permission to appeal, then the fact that there had not been the opportunity to get a reference to the Court of Justice might not be significant. So the upshot in that case was that the Supreme Court decided that where an issue of European Union law arose, it would in future give reasons for rejecting the application for permission to appeal. And it then decided that it should extend the same practice to all cases and give reasons for refusing permission to appeal. And at that stage, that was regarded as sufficient to dispose of the particular issue as far as the United Kingdom was concerned. But it is a somewhat difficult issue because of the rather unusual feature in the United Kingdom that appeals to the Supreme Court are a matter which is optional for the Supreme Court and not obligatory. Of course, in most member states, there is an automatic right of appeal. The result is that those courts are sometimes deluged with huge numbers of cases, but at least it means that theoretically there is not the difficulty that arises in the United Kingdom. Now, there have also been corresponding problems in Sweden, and the Lickeskog case, and I think that there have been some problems in other member states also. And sometimes it's simply a question of practice, that there do not seem to be many references from the Supreme Courts, or some of the Supreme Courts of the member states. It is difficult, of course, to argue from that there has been any kind of systematic approach of not referring. But again, I think that this is a matter of historic development. I remember at one time it was said that the French Conseil d'État, which was the supreme French court in administrative law cases, never made a reference to the Court of Justice, and indeed sometimes also failed to apply European law with no remedy to the claimant. The attitude of the French Conseil d'État evolved very substantially, and now is very enthusiastic about European law. Certainly its president is extremely positive about European law. So I think this is partly a question of historical development, and I think there is really some difficulty in taking proceedings in respect of failure by the courts to comply adequately with their obligations under European Union law. The idea that the Commission should bring proceedings in respect of that against member states might be seen as to raise a question about judicial independence. Ideally, the problems would be solved in other ways. But I suppose that it should also be mentioned in that context that the European Court of Justice has gone a long way in encroaching on judicial independence by holding that member states may be liable in damages if the national courts misapply European Union law, so that if you get a judgment from a national court which is clearly contrary to European Union law, the person who is prejudiced by that judgment may bring a claim for damages in the national courts in respect of that failure, that breach of European Union law, which is quite a far-reaching decision. And again, I suppose, should be followed only in rather extreme cases.
All right, then. Any other questions?
Thank you for the lecture. You touched upon the quantity of the references made by the national courts. Can you comment on the quality issue? Are there any typical mistakes what the national courts make?
Well, the quality of the references made by the national courts, I'm a little bit reluctant to give chapter and verse, so to speak, on that. We did have experiences at the court where we had some rather inadequate judgments from some national courts. Sometimes one side of a piece of paper written in by hand by the judge, and not really giving any adequate account of what the case was about. In a very extreme case, such a supposed reference would not even be registered, I think, by the registry of the court. But I think, again, I think that standards have evolved since the earlier days, and of course knowledge and understanding of the system have increased enormously. But I think one has to bear in mind that every court and every tribunal in the European Union, established by law anyway, is entitled to refer. So there are bound to be variations in standards. I mean, you have, to take England as an example, you have some magistrates in England who are not legally qualified, but who may be entitled to make a reference. They may be assisted by a clerk who has some legal qualification. But that's the lay magistrate is a rather significant part of the English legal apparatus. So I think there are bound to be considerable variations in quality, but it may be better to leave the answer there rather than give you more examples of the difficulties that can arise. What I would say is that however inadequate the reference may be, and I'm not suggesting any of the cases which we may have been familiar with here, the court does its best to find out what the questions really were and to give a constructive answer. Now, I would say just a word about that because I think it's very relevant to the question of judicial dialogue. I think that the criticism is sometimes made of the Court of Justice that it's not really dialogue, it's rather one way. That's to say, the national court asks a question and the Court of Justice answers it and may not answer it really with the concerns of the national court in mind. Why doesn't the Court of Justice, if there's a difficulty with the reference, why doesn't it go back and ask the national court some questions to find out what is really at stake? That's a fair comment, I think. I think, and the answer again, I think, is purely practical. There are practical difficulties in going back to the national court. For one thing, in many jurisdictions, if you go back to the national court and ask them questions, they would then have to reconvene the parties. It wouldn't be sufficient for the judge just to answer the questions. The judge would have to reconvene the parties, the proceedings would have to start afresh, there could be appeals and so on. So it's not as straightforward as it may seem, this idea of dialogue. And that's why, of course, it is so important that all the information and all the matters which might assist the Court of Justice are put in the initial reference. It won't be normally possible to go back. There is the power to do so, but that power will be exercised very rarely because of the practical difficulties that are likely to arise. And then you get the question, well, at what stage is this reference going to be sent out to the parties and to the member states? Do we do that straight away, or do we wait until we've got the answers from the national court and so on? So it becomes quite complicated. And I think, in most cases, it will be possible for the court to work out what is really involved. It may require a certain amount of research, but to find out what is involved and try to give an answer which is going to be relevant and helpful to the National Court.
All right, any other queries?
Thank you for the lecture. And my question is the ruling by European Court of Justice is also binding for the state authorities of member states?
Binding for the...
like administrative authorities.
Administrative authorities.
Yeah, when treating the similar case.
Right. Yes, I think I can give a straightforward answer to that question. I think the ruling given by the Court of Justice in reply to a reference will be binding on the administrative authorities. Yeah, I talked about it being binding on the courts, but I think it is apparent that from that it is really also binding on the administrative authorities, because if the matter were to be tested in the national courts, if the action of the administrative authorities were to be challenged before the courts, then the national courts would have to apply the ruling of the European Court of Justice, so that must be taken as binding on the administrative authorities, and indeed on all the authorities of the member states. Simply binding, if you like, binding on the member states generally. And there have been some cases to that effect. There was a case many years ago called Costanzo, and the question there, I think, was whether an administrative authority in a member state was bound to recognize the direct effect of a EU provision, and therefore not to apply a national measure which was contrary to that provision. So the question was an administrative authority bound to do that without any question of it being taken to the national courts? And the answer was that the administrative authority was bound by the provision and had to apply it. I think there's also some case law to that effect. So I think generally one can say that that decisions given in a preliminary ruling are binding on all the authorities of all the member states, in effect. Otherwise, it would not be uniformly valid. So, yeah.
Thank you, Professor. My name is Gustav Gailis, and my question is about access to justice of the general public in direct cases before the ECJ to challenge acts of the EU institutions. Namely, the ECJ has been extremely reluctant and restrictive in allowing members of the public, including NGOs, to challenge, for example, decisions or regulations by the EU. Let's remember, for example, the Plowman criteria as well. The last well-known case that I can remember is from last January, when ECJ decided to dismiss a claim by an environmental NGO, and this NGO argued that regulation was contrary to an international convention, that the EU was a party. It's a story about the Aarhus regulation and Aarhus Convention. The interesting aspect is also that the General Court in the same case, and also the Advocate General before the final judgment, had suggested that the NGO was right, and the General Court had adopted a judgment in favor of this claim, and also later the Advocate General suggested that the NGO was right in its claim. However, the ECJ at the end of the day dismissed the claim, and could you please comment how do you see this trend could develop in the future? Do you see any possibility for a change in the near future? Thank you.
Isn't that a déjà vu sort of situation?
Well, indeed, there is an element of history there, which I was familiar with, because I had a case some years ago at the court when I was Advocate General in relation to the question of standing of individuals to challenge EU measures, and I took the view that the court's case law was too restrictive, and I was followed in effect not by the Court of Justice, but by the General Court, which in a case pending before the General Court at the same time, the General Court also considered that the approach of the Court of Justice was too restrictive in enabling individuals to challenge measures before the EU courts. But at that time, the European Court of Justice did not accept that view. It rejected the position of the General Court, and it didn't follow my opinion. However, it did, in its judgment, this was a case called the Unión de Pequeños Agricultores, or UPA for short, it did say that this was a matter for the member states to amend the treaty if they thought it necessary. And while the court itself was not enthusiastic about the treaty being amended, the treaty was in fact amended. And one of the important amendments made was that the requirement in the treaty that the applicant should have individual concern before the applicant could challenge the measure was removed. So that was really a step forward, but unfortunately the case law of the Court of Justice has not really given full effect, I think, to the new text. The Court of Justice is still reluctant to receive applications by individuals. So there is a problem with the access to justice, and particularly, of course, as you mentioned, under the Aarhus Convention, which is specifically designed to give individuals wider access to the courts in environmental matters, where, after all, otherwise, how does it come before the court? Because no particular individual is individually concerned by an environmental measure. Normally, everyone is concerned, but there is no particular test of individual concern. So I would say that the approach of the Court of Justice is still too restrictive. However, I must also balance that by saying, as I mentioned at the outset, that the Court is willing to receive challenges to the validity of EU measures. So that can be done by getting a reference from the national courts on the validity of the measure. And there the Court of Justice has been rather receptive to those references, in contrast to its attitude to direct actions by individuals before the court, where it has been very restrictive. In relation to references on validity, it has been very positive, and it's been practiced in recent years for the court to entertain such actions, even though it is argued that it may not have jurisdiction. For example, because the measure has not yet entered into force. I might say in passing that the English courts have been used a good deal to make references of this kind, challenging general EU measures. The English courts take a broad view of their jurisdiction, so they have sometimes referred questions on the validity of measures even before they have been introduced, asking whether it would be valid for the EU to adopt a particular measure. And they have not objected to referring the question, and the European Court of Justice has occasionally given an answer. So, to some extent, that balances the lack of direct individual access before the courts. So there is that possibility which can be widely used and has resulted in one or two remarkably, cases where the Court of Justice has decided that the EU has acted unlawfully, which is quite unusual for the Court of Justice to overturn a legislative measure, but it has done so. I think one of the first examples many years ago was the Tobacco Advertising Directive. That was overturned partly on a direct action by Germany, but also on a reference from the English courts. And more recently, in the case of Digital Rights Ireland, where the Court of Justice got a reference from the Irish courts and decided that the EU directive was unlawful because it infringed the requirements of adequate data protection. So there are those alternative channels, and the court seems to prefer. One can argue that the procedure in a direct action would be more satisfactory because you have a proper exchange of argument that you don't get with the reference procedure. But the court seems to prefer to have the question brought before it on a reference from a national court rather than in a direct action.
Any other questions? Maybe I will just chip in some of the questions relating back to of this particular Plowman formula problem and the court's attitude. How do you explain why the court has been so reluctant in allowing direct actions and at the same time favoring preliminary references on validity? Isn't it the reason that they actually know that not so many cases will, let's say, come to their tables through national courts in this way?
Well, I really don't know. I don't know why the court has been so reluctant. I think at one time there may have been a fear that the floodgates would open. If they allowed individual access, they would be flooded with thousands of cases from across the European Union. But that fear receded, of course, when the Court of First Instance was established, because all those cases would have to start with the Court of First Instance. The Court of First Instance would decide them, and only the appeals would go to the Court of Justice, and the Court of Justice could deal with appeals in a rather summary way if they considered that the Court of First Instance had got the right answer. So that particular argument disappeared, and especially in the light of the fact that the Court of First Instance seemed to welcome a broader approach to individual access in its judgments in the case which I mentioned 15 years ago, and also in the case on the Aarhus Convention. So that particular argument, which might have been a strong argument, does not seem to have been that significant in retrospect. And I don't know. I find it difficult to understand the argument that the court has to follow precedent is not a very convincing one, because the court sometimes manages to develop the law. The argument that the treaty interpretation taken literally requires limited access is not convincing, because in constitutional cases the court is often willing to take a much broader interpretation, sometimes even decides constitutional cases contrary to the express wording of the treaty. So that's not a very convincing answer either. One might think that the court has some predisposition to see itself as not being a court open to individuals by way of direct action, but only to individuals who come via a reference from a national court. But why that should be, and whether maybe different judges have different reasons, that's impossible, I'm afraid, to answer. So I really don't know. And as I say, I think all one can say is that the opportunities for the question to be put, so long as the United Kingdom is a member of the European Union, and its courts are very ready to put these questions, not out of any particular attitude towards the measures themselves or towards the European Union, but they simply have in the United Kingdom, the English courts have a particularly open approach to judicial review, which has developed very substantially over the years, and I think they would continue to be willing to put such questions.
And also very practical question, returning back to preliminary references. I mean, in your practice during these years and in the Court of Justice, in terms of a really practical point, the size of the reference in terms of A4 format pages. I mean, first of all, what is the longest reference you have ever seen, and what's the shortest one? and what's your opinion on, I mean, the optimal size of how long should the reference be actually?
Yes, I think that's a question I can answer. I'm not sure that I can remember exactly how many pages, but I would think probably something going up to about 100 pages. And of course, again, in terms of UK litigation, that might seem rather short, because the documents tend to be extremely long in English proceedings. The shortest would be certainly one page, and that would be like the page which I mentioned, which was written by hand, and very, very hard to decipher as well, I might say. And the optimum number of pages, I think the court at one stage indicated that 20 pages would normally be, should normally be sufficient for a reference containing the information that the European Court of Justice would find helpful. I mean, obviously it's a very arbitrary selection, but I think it is still a good idea to give some notion of what would be an appropriate size for the reference. So I think if one worked on 20 pages, and at one time I think the court took the view that if the reference were more than 20 pages, then the full text would not be translated into all 24 EU languages. There would be a summary. And at one time, I think there was even a suggestion that the National Court should be asked itself, if it were going to exceed 20 pages, to provide a summary, but I don't think that was actually put into practice.
All right, still any questions maybe? Yeah.
Thank you very much for the lecture, Professor. You mentioned about the issue that European Court of Justice is balancing the fundamental rights against economic freedoms and economic rights. And my question relates to the European Court of Human Rights introducing a similar mechanism to preliminary reference through Protocol 16. And it seems that European Court of Justice rather promotes economic rights in the light of Laval and Viking, and do say if you disagree with that. So my question is, if the new mechanism for Court of Human Rights is enacted, do you think there would be a conflict between the two systems so that the applicants might cherry pick whether to refer to European Court of Human Rights or Court of Justice, and how would Court of Justice deal with that?
Yes, well, that's a very interesting question and raises a lot of difficult points. I think, first of all, I personally don't think the idea of preliminary references to the Court of Human Rights is a good idea at all. I mentioned the cases where the system has been borrowed and where one can understand that system, but it seems to me it's not really appropriate, if I may express a view on that, in the context of the European Convention on Human Rights, for a number of reasons. Partly, I think, I don't think it's a good idea simply because you've got the mechanism of the individual going direct to the European Court of Human Rights. And that way the Court of Human Rights can look at the whole question in the context of a practical case rather than being asked a question in the abstract. It's in a way the reverse of the EU system, where the individual can't go, but the national courts can put questions. I don't think you need both, really. And secondly, I think there's a reason of principle against it as well, that the system of references is important or even necessary where you want to have a uniform body of law, and that has been the case with all the examples that I mentioned. In the field of economic law, for example, if you want to have a single market, you've got to have a uniform application of the law. In the field of human rights, you don't need uniformity, and the Court of Human Rights is not there to provide for uniformity. It's to provide a minimum threshold, a floor, and states may go further than the protection required by the Convention. In EU law, you have got a uniform standard. Member states can't go further. So I think it's a misconception to introduce references to the Court of Human Rights, first place, if I may be completely candid on that subject. And I think that there's no reason really for competition between the Strasbourg Court and the EU Court, because it isn't a question of it isn't really a question there of difficulty in the relationship. It's the position is rather clear as things stand at the moment, that if you are raising a point of EU law in the Court of Justice, you can invoke human rights if you take the view that in a case like Laval or another case, the court has not given sufficient regard to human rights, then you can go to Strasbourg, as was done, for example, in the Bosphorus Airways case, where it's true that in the Bosphorus Airways case, the Strasbourg court said it wasn't necessary to review the EU action, but nonetheless, in principle, you have the right to go to Strasbourg if you get an unsatisfactory answer from Luxembourg, because the Luxembourg measure will then be applied by the member state, and the member state's measure can be challenged by the individuals concerned in Strasbourg. So it seems to me that the relationship between the EU and the Human Rights Convention was really quite satisfactory. It's also, of course, been rather disturbed, as it seems to me, by the EU Charter, but that's another story. Maybe also, in some respects, an undesirable change in the system, which makes it a great deal more complicated. But that's perhaps something for another day.
Any other questions? All right, maybe the last and finalizing point, which is not related at all with the subject matter of this lecture, but still is very, very topical indeed, and obviously that's a referenda in UK. I mean, what do you think, how do you foresee Europe going forward? What's the implication of this referendum, and also against the background of you being optimistic about English being an official language of the court? Do you feel in some ways that there is a potentially some way how the UK can still remain in one or another way around the EU?
Well, I am afraid I'm reluctant to try to make any prediction, because what I have learnt over the last few days is that every day brings a complete change in this political scene in England, and the picture is changing from day to day, and I think anything can happen. And I think one of the great problems, of course, is the uncertainty and unpredictability that are the result. There are many things I would like to say about the referendum. I don't think I would like to predict how things could evolve. I mean, of course, one possibility might be that the United Kingdom accedes to the special status of the non-EU members of the European Economic Area, in which it might still have access to the internal market and might be subject to the other court. But I think it's simply impossible to predict how things are going to evolve. Not sure I can go any further than that.
All right, thank you very much indeed for a very interesting presentation, and I'm giving the floor to head of the Latvian Bar Association, Guna Kaminska, for a short thank you message.
Thank you.
Professor Jacobs, I am honorable to give you these flowers from all of us as a thankfulness for your useful presentation. As you see, my English is not so good as to my young colleagues. It's firstly. Secondly, you give us your experience, your knowledge. I will give you Latvian lawyers' voices.
Yes. Thank you very much, and thank you all for your interesting questions too, and thank you for giving me the opportunity to take part in this.